Thanks, Ken. The first thing I should do is complain about being second because what she said, I agree with it all, and that's it. No. As you see, the title is One Man's Opinion. And this is my opinion of what should be in a report based on being in this field for 30 years. And I must admit that when I first joined the police agency that I was with some 30 years ago, the reports were classic as far as this looks like that, and I use standard scientific principles. How could you go wrong, right? This is like that, and I use standard scientific principles. So I guess the real question here, as this slide points out, is should we put down in writing or shouldn't we? What's a report? You know, we have all these what should be in a report. And so I decided maybe I'll look this up in the dictionary, see what a report is. And it's to make a statement of facts. Or an account returned, a statement or relation of facts given in reply to an inquiry. Well, maybe we should think about this a little bit. Is our report a statement of facts? Is it? Secondly, if we're only going to return as a reply to an inquiry, what does that do for the report? I mean, I've seen so many requests when I was in the lab. Classic request, somebody sends in a coffee cup that's got some stain in it, and they say chemical analysis. What does that mean? How much carbon, hydrogen, and oxygen is present? Whether there's coffee in that cup? Or do we reply that what they're really interested in after you make about a dozen phone calls is there a poison in the coffee? So I think that the report is more than a reply to what the police investigator asks you, especially based on the fact that they usually ask you the wrong question, or they don't ask any question. Those of you who are familiar with doing trace evidence from crime scenes, you get a box with 50 bags in it, and now you're supposed to figure out what to do with it. There is no question, right? I think your report has to have opinions, conclusions, data, and references. There's some guidance for this for us. We can, besides what Maureen talked about, there have been Astm guidelines, ASCA Lab has guidelines, SWGMAC suggestions that I'm going to talk about based on the Glass Group's draft of 2001, ISO 17025, and court requirements, the federal rules of evidence, the federal rules of civil procedure, and the federal rules of criminal procedure. One man's opinion. And one thing about opinions is everybody and everybody has at least one on anything. Sometimes, if you have the right group, you can have 5 people and have 8 opinions, but that's a different issue. I say you include everything. Facts, opinions, conclusions, basis of your opinions and conclusions, the methods that you use, the data, the references that you relied on. Did you use references for your conclusion? Did you look in some classic text? Did you use articles, journal articles? Your expertise, which includes your education, your training, your experience, publications, etc. And the last one, which I don't think I heard Maureen mention, limitations. You mean you want me to put in a report what this testing didn't show or what the bad points about what I learned? Yes, I want it in there. That's what I feel. ASTM has a number of these. You can, this PowerPoint they have, and so you don't have to write any of this down. There's been a number of ASTM guidelines that are being modified now about what should go in reports. And you can look those up. This draft, this glass draft, I want to talk about this glass draft a little bit. This was a straw man that I was assigned to put together in 2001. And after we beat it to death in the glass group for a couple of years, then it went out to the general SWGMAT, and it's been changed or altered a little bit, but I still have certain strong feelings about what was originally discussed. One of the things about report content that you see here that Maureen didn't talk about is what about oral reports? How many of you get the request for that? Or just tell me what it is. And then when you tell them the answer, they say, well, you don't have to write a report now, right? Why? How come the Investigator doesn't want to report because your results were what? Exculpatory, right? So he said, well, don't write that report. Just, that's fine. The other thing about this that I should mention here, I would assume 95% of you in this room work for some sort of a police agency in one way or another. So you're always thinking about criminal cases. But almost any type of trace evidence that you can deal with can be largely involved in a civil case. And the civil case issues are even broader. So if an attorney calls you and he says, look at this evidence, and it doesn't fit his program, he says, don't write a report. Well, you really can't, or it gets very difficult to write a report when you're told not to, but I felt that if you decide not to issue that written report, you should at least make notes of it in your case jacket. On so-and-so date, investigator so-and-so called me, or prosecutor so-and-so called me, told me not to issue a report. And then I would send that person a note, whether it's an email or a letter, saying, no report will be issued as per your request. Because what happens down the line, 2 years down the line, when they say, where's the report? That ADA is gone. He's retired. Right? The investigator's gone, and in my type of parlance, which some of you used to hearing me say, you're left holding the bag. So you need to have those records to protect yourself. All right? Same as when the client is an intermediate user. All right? Incidentally, I think I mentioned this. I'd like to bring this up here because most of this stuff that I have, Maureen covered. Who's the client? I mean, Maureen said, main reason we don't want to issue these big reports is the client doesn't care. Well, who's the client? Is it the police agency that called you originally? Is it the prosecutors? Are they the clients? Or is it the court system? Is the defense attorney your client? Think about that. Is the entire social system or criminal justice system your client? I think they are. They're all your client. Oops, wrong key. There you go. What should be in the report? It should say whether this is a preliminary, supplementary, or for investigative purposes. Sometimes you write a report, it's only for investigative purposes. And you should say this. Maureen mentioned identification number, some sort of way of identifying that. The agency, unit, company, organization, or person issuing the report with proper address and phone number. Name and address and affiliation of the person who is rendering an opinion or generating the data or opinions if it's different than the person who is sending the report. Sometimes we send things out to someone else where there are a number of people in the laboratory. I think everybody should be identified. Who's asking for this? A general description of the items and places examined. Sometimes your report or your case that you handle involves a scene investigation. That scene may be important for your interpretation. You need to identify that. Unique identifier system, we talked about that. Date and location of the examination and identification of people doing the examination, if not the one doing the report. Purpose for which the examination was made. Sometimes it is important to say why you're doing what you're doing. A general scope of the examination and investigation and the conclusions or opinions that are reported. The report shall contain all facts that are significant and pertinent to the conclusion reached. Right? These shall be reported in agreement with the items listed below. Facts that are based on personal observations, measurements, examinations, etc. Everything you do, all those facts should be documented. Other facts or information relied upon by the examiner should be clarified or mentioned and identified. What do I mean by that? Sometimes your opinion will be modified or is based on outside extrinsic information. Now, we heard a discussion this morning about, well, should the analyst be, Dr. McKenna mentioned, isolated from outside information? My personal opinion is no. Not when you're drawing a conclusion, especially of common origin type things. I remember Skip Pelnick told me a story once, and I'll probably mess up the facts, but the gist will be correct. The question, if I recall it, was he received a weapon, a folded knife, and he was told to examine that weapon and then see if he could find any trace evidence indicating that that weapon was in a certain person's pocket. So he got the pocket and he examined that. He looked for all the trace evidence, and then he looked at the weapon and he found some unusual particles on the weapon. And he said, based on all these particles that I found on this weapon, I don't think it was in this pocket. Well, what was he basing that on? The fact that he should have had this transfer evidence in the pocket. And he's on the trial. The person said, well, what'd you find? And it had to do with some like grayish type particles, and there were quite a few of them. Said, Mr. Pelnick, might you change your opinion if I told you that that folding knife was dusted with fingerprint powder? Yeah, sure it would, because that explains all these particles that weren't in the guy's pocket, right? The guy doesn't walk around with fingerprint powder in his pocket. So sometimes it's very important to know this other information. Facts that are based on personal observation we talked about. Other facts and information we talked about. Equipment used in examination. I don't think it's sufficient to say I did mass spectrometry. Simple as that. Now, sometimes you might mention the model number or the make. I don't think you have to go down to serial number, et cetera, but you should certainly mention what kind of technique. Calibration data. My reports that I send out now that I'm in private industry, I actually include the calibration data from before I did the analysis and after, because in law there's a presumption of continuance, right? If everything's working, I learned this as a cop on the street. The red light was working before the guy went through it, and it was working after he went through it because I timed it. Now the judge has got to agree that it was probably working when the guy went through it. Because you never can prove that your instrument was working perfectly when you did that analysis. Correct? You can't. You can show it was working before, you can show it was working after. So I think calibration information is important. It can be in an appendix. This doesn't have to be stuck in the body. Whenever pertinent findings of fact are established through the examination or testing, the person rendering the opinion shall have either performed, supervised, participated in, or observed the examinations. Now, I know in our field of practice, we often have medical examiners testifying to the results of distance determinations performed by someone else that they have not observed, they don't know. And I think that's bad. That's my personal, again, one man's opinion. All the conclusions drawn by the examiner from his testing, observations, review of facts, and other information as well, blah, 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 should be contained in the report. Any and all major references relied upon for information or for drawing your conclusions or opinions should be cited in reference. You mean I have to tell my clients, or worse, those defense attorneys, where I got this information? Yes. The reasoning behind your conclusions and opinions, not just I drew this opinion. The uncertainty of any pertinent measurements, conclusions, or opinions. Now, I know this whole, and I disagree with a lot of people on this, everybody's panicking about ISO 17025 and uncertainty. I don't think it's that big of a deal, all right? You should know the uncertainty of your physical measurements anyway. I know at John Jay, I still use a syllabus type that was developed by Chuck Kingston, I guess 35 or 40 years ago. Every student has to report any quantitative result with an uncertainty number. And if you can't do a direct standard deviation, because you don't have lots and lots of repetitive numbers, remember it's an estimate of uncertainty, and that can be done by error propagation. So it's possible to do this without panicking. Optional information. A report may contain the following information. It is suggested that it may, so you can do that too. There's lots of other things you can put. Now, examiner qualifications. I think it should be in there. All right? Licensing, certifications, accreditations should all be in there. You mean I'm going to tell the defense attorney, or I'm going to tell the prosecutor in my report what my experience is? Yes. As I hope to point out later, this is going to save time, because they're going to want to know why should they believe what you said in that report? Right? Why should that prosecutor think that this report issued by you is valid? May as well supply the information up front. All right. Appendices I mentioned. Now, this part here, not in the 2001 draft, these are things that I want to address here if I have time, and that is disclosure requirements. Almost everything that I mentioned in here, not only is it listed in ISO 17025 and in ASTM and other things, you're going to have to reveal it anyway. It turns out it's very interesting that the Federal Rules of Criminal Procedure, Rule 16, and the Federal Rules of Civil Procedure, Rule 26, are slightly different as far as what the statute says for scope, and civil disclosure is more extensive. We have to supply more information to the other side. Now, is that the way it should be, you think? Isn't it interesting, America, right? When somebody's freedom is involved, we don't have to tell the other side about it. But if it's money, well, then we have to tell the other side everything if it involves good old American buck. I applied some of this discussion about Standard 17025 based on laboratory accreditation in a program that I'm familiar with, which is NAVLab, the National Voluntary Laboratory Accreditation Program for Environmental Testing. And this is all found in, under NIST Standards and Technology Handbook 150. And NIST's program for environmental testing for asbestos, they are accredited by ISO to accredited laboratories. So that means their standards have to meet this. And again, I'm not going to read these all out, but you'll see these things, these titles and these sections from the NIST handbook cover the exact type of things that we're taught, that we just spoke about. In addition, all right, they talk about something that Maureen mentioned, and that is if you deviate from your SOP, are you dead? Are you dead? I mean, as an outside consultant, I love to have your SOPs, because if you didn't do what's in the SOP, what happens? Come on, don't just, what happens? I get you understand? You use this SOP here. What's it say here? It says I should measure 15 milligrams. What'd you measure? 13. You have trouble now. Why did you measure 13? Because that's all the sample was, right? You can't weigh out 15 if the cocaine sample is 13, right? You're supposed to put that deviation into your report. It will not kill you. It's not fatal to not have followed your SOP perfectly. Your quality assurance manager or your boss may say, well, we're not going to issue the report. That's a different issue. That's a policy issue, right? Statement of uncertainty. DWI cases. Boy, do they hate to say the blood alcohol. Well, when I was doing it, it was 0.15. We were allowed to be a lot drunker. Now it's 0.08, right? Nobody wants to put plus or minus 0.01. Oh, you mean it could be 0.7 and my guy wasn't drunk? Yeah, but you have to put that in there. ISO is going to require it. All right? What about controlled substances, right? All right? Same thing. How many milligrams of cocaine or what percentage is going to make this a felony charge rather than misdemeanor or higher felony? You have to have uncertainty here, right? In addition, the report shall contain results of sampling where necessary for interpretation of results. Right? What am I talking about? If you get 10,000 packets of heroin in, and you're only going to analyze 100 of them, right? And then you get 100 of those packets all contain heroin, they're all packaged the same. Are you allowed to draw an expert opinion that all 1,000 packets or 10,000 packets have heroin? What do you think? Raise your hand if you say yes. Raise your hand if you say no. Raise your hand, as somebody said, if you're awake. See, nobody's, 3 people, that's fine. In New York state law, that's a valid expert opinion. I tested 100, there were 10,000, they all contain heroin. It's a valid opinion, it's admissible. The weight of that opinion is a different issue, but it is admissible. Okay, good, rolling along here. Federal Rules of Evidence. Expert may be required to disclose underlying facts and data, which we hate to do, for his opinion under cross-examination. Now, that's not too dangerous. But what about federal rule of criminal procedure? Reports and examinations and tests have to be disclosed. Results and reports, any scientific test or experiment, not just the ones that agree with your opinion, right? Expert witnesses in a written summary of the testimony with the witness's opinions, bases, and reasonings with qualifications, okay? Civil procedure, right? Expert witnesses supply a written report, even more. Same things as criminal, but also your qualifications of the witness, list of publications in the past 10 years, what compensation you're being paid for that case, list of other cases wherein the witness has testified at trial or deposition within the last 4 years. Now, I mentioned this thing about civil cases. Just because you're involved in a criminal case, don't think it wouldn't turn civil at a future time. What famous case has that? Yes, well, that's good. O.J. Simpson, right? And he's found not guilty, but the civil case said he caused the death of. I'll leave that to Professor Gianelli to discuss, right? So we're summing up here, because I have 5 minutes. Have no fear, state your opinion. That's what I want to tell you. Don't be afraid to state your opinion, even if it involves establishing common origin or not. And even if you must use statistics, you don't have to panic about that. Does a report content influence testimony? Giving of evidence, okay? For those of you who are not from the States. I say resoundingly yes. First thing, if you prepare a complete and concise report with all the things Maureen talked about, and my opinion, and what ASCOT says, and ASTM and ISO, that preparation crystallizes your thinking and pulls together all the supporting data so you have it in one place, so you can analyze and think this whole thing out. It's like having a notebook. Those of you who have done research in the laboratory, there is a good reason to keep a notebook besides your professor requiring it. And that is when he tells you to perform another experiment a year into your research that you've already done and forgotten about, you find it in the notebook. Now you don't have to do it twice, right? It can help prevent over-testimony. We've heard some discussion about people write a report and then get into court and say much more than they have in the report. That's not good, right? It can also assist in avoiding under-testimony, right? You say all these wonderful things in the report, the prosecutor prosecutes this guy. Now they get to court and you go, well, yeah, maybe it came from there, but then again, this is a white cotton fiber and they're all over the place. So that helps that. It works wonders in moderating overzealous prosecutors and attorneys. That's my experience is when you have it down in writing, it prevents them from trying to force you into an untenable position. Summary conclusion. Complete and comprehensive report with supporting material leads to a higher level of forensic performance, in my opinion, and it's in the overall interest of justice. Now, what do I mean by that? You write a vague report, right? I could not exclude this guy, right? Now they go through he gets indicted. It goes to, there's hearings, nobody understands your report. It goes to trial, and the bottom line is, you say, well, yeah, I couldn't exclude him, but so what? It really doesn't mean anything. And he's judged not guilty. Why go through all that trouble? Why should a defense attorney talk somebody into pleading guilty, copying a plea based on your report? And everybody says, oh, I would never plead guilty to a charge if I didn't do it. Don't believe it. Right? When they offer you a jaywalking ticket instead of the speeding ticket, you might do it. Now, of course, when you get into more extreme cases, that's different. People do it all the time. Right? They're advised by their attorney. If you plead guilty, you'll do 6 months downstate. If they convict you, you're going to do 5 years. Pelican Bay? Does it mean anything to anybody? Right? Okay. I'll plead guilty. Right? I'll go to LA jail. I don't want to go up to Pelican Bay, right? What constitutes this, as far as the report, seems to be agreed upon by all the references we've seen so far. Therefore, maybe it's not one man's opinion, huh? Maybe it's everybody's opinion, and it's time for us to comply. Thanks for your attention. If you want a printed copy of this, just contact me at P.O. Box 208, Green Lawn, by postcard, and I'll send you a copy. And that's my remembrance of New York, how I wish it still was. All right. Thank you.